Conference participants, thank you for coming. Dear colleagues and students, remaining members of the audience, thank you for being here today. I'm Juscelino Collares, Professor of Law at Case Western Reserve University School of Law and chair of this panel. I'm thrilled to be with you this late morning and to have the chance to introduce our panelists. My colleague, Jonathan Adler, is the inaugural Johan Verhage Memorial Professor of Law and Director of our Center for Business Law and Regulation. He teaches courses in environmental, administrative, and constitutional law. John is one of legal academia's most prolific and cited writers, having published several books and articles. He has testified before Congress numerous times, and his work has been cited by the United States Supreme Court also before. Adler is a contributing editor to National Review Online and a regular contributor to the Volok Conspiracy blog, now hosted by WashingtonPost.com. Prior to joining the faculty, John clerked for the Honorable David B. Santel on the United States Court for the District of Columbia Circuit. From there, John worked at the Competitive Enterprise Institute from 1991 to 2000. He holds a BA Magnum Cum Laude from Yale University and a JD Summa Cum Laude from George Mason University School of Law. Following John, we're going to have Professor Uma Utke speak. She's been Associate Professor at the University of Kansas School of Law since 2011, where she has written at the intersection between energy law and environmental law with a focus on renewable energy and the transition to a low-carbon electricity sector. She teaches courses in energy law, property, environmental law, and climate change law and policy. In 2013, she was the recipient of the Moreau Faculty Award, an honor bestowed on a faculty member by the entire student body. In 2015, she received the campus-wide Sustainability Leadership Faculty Award. Professor Utke's scholarship has appeared in several law journals, including the Vanderbilt Law Review, Ecology Law Review, Colorado Law Review, and Stanford Environmental Law Journal. Before becoming an academic, she served as general counsel for 1,000 Friends of Florida, a nonprofit advocacy organization focused on growth management and environmental issues. She's a summa cum laude graduate of the University of Maine School of Law and holds a master's in public policy and administration from the Muskie School of Public Service. Please allow me to tell you a bit about how we will proceed. First, I'll give a brief, first, of course, I gave this presentation. Second, I will provide my own brief remarks about the theme of our panel. Third, starting with John Adler, Professor Utke, and legal advisor Benias, each panelist will have about 12 minutes to present their ideas. Following the panelists' presentations, I will get to ask each one a brief question for which I respectfully ask them to offer a reply within about 2 minutes. When those initial questions are out of the way, we will turn to the remaining time to the audience questions and panelists' answers. To minimize the possibility of hunger-related grumpiness, we will conclude this panel around 1:15 and continue any eventual conversations over lunch outside. One more administrative legal matter. Legal advisor Benias' remarks are off the record. We will not be video recording her remarks. And while her participation in the Q&A will be recorded, she asked me to indicate that any answer or comment she gives does not necessarily reflect the views of the United States State Department. So, on to my very brief comments. Again, the name of our panel, Regulating and Treaty Making, Addressing Climate Change under the Obama Presidency. The scientific community has made straightforward, unequivocal findings that greenhouse gas emissions from anthropogenic sources have very likely contributed to climate disruption and are on track to induce further changes, mainly through temperature increase in the years to come. Early skepticism about climate change disruption, stage 1 of climate denialism, gave way to stage 2. Is it human-caused? And in some cases, to stage 3. Are the climate models accurate enough? For instance, in a hearing on the Department of Energy's 2014 budget, in a response to a skeptical West Virginia congressman's question about whether there was a scientific consensus that climate change is caused by human activity, Secretary of Energy, MIT physicist Dr. Ernest Moniz replied, open quote. First of all, the rise in CO2 emissions in the last half century is clearly tracked to our global increased energy use. Secondly, I know how to count. I can count how many CO2 molecules have gone out from fossil fuel combustion, and I know how many additional CO2 molecules are in the atmosphere, end quote. And before he could say, quote, third, scientists understand the heat-forcing properties of CO2 in the atmosphere and the consequences of that heating on Earth's climate, and this is my own made-up quote, by the way, he was interrupted. Clearly, Congressman David McKinley, a representative from West Virginia, wasn't interested in a scientific explanation of climate facts. Indeed, only in an ideal polity, as in the Rawlsian, veil of ignorance metaphor, does science-based policy invariably lead to legislative action and the production of public goods, such as clean air, clean water, and greenhouse stabilization. In the real world, regulation that results in diffuse benefits to society does not tend to fare well against special interests facing the possibility of increasing costs through regulation. So political economy constraints help explain why the last attempt at climate legislation died in the US Senate. I'm referring here to the Waxman-Markey-sponsored American Clean Energy and Security Act of 2009, which died in the Senate. Despite being loaded with pork, Waxman-Markey failed not only because of fossil fuel industry opposition, but also because unilateral attempts to internalize the social cost of carbon by charging for emissions raise costs to carbon restricting first movers, in that case, the United States. True, Waxman-Markey had a provision authorizing border carbon adjustments, or tariffs, that would in principle restore the competitive balance between U.S. products and imports from carbon-friendly countries. Yet, ideological opposition to a giant bill affecting so many sectors of the economy proved just too strong. Since then, any updates to the Clean Air Act, last updated in 1990, by the way, 25 years ago, as well as this conference, are out of question. Because climate change litigation has not gone anywhere in the United States as well, as demonstrated in an empirical study I published last year in Jurimetrics, President Obama has basically two major tools with which to mold the United States approach or response to climate disruption. Domestic regulations under existing authorities, and mostly the CAA in that case, and treaty making at the bilateral and multilateral levels. Our panelists today will discuss these alternatives, their limitations, and how they mesh with each other. We should welcome them and thank them for sharing their expertise and for making us wiser. Thank you. John?
Thank you, Juscelino. It's a pleasure to be here. I'm not Michael Wera, who was originally supposed to talk about some of our domestic policy initiatives on climate, but I will do my best to be an adequate substitute. What I want to talk about is the use of the Clean Air Act as a mechanism to reduce greenhouse gas emissions. As Juscelino already noted, this was not the Obama administration's original plan. The plan had been to sign legislation, such as the Waxman-Markey bill, that would create a framework that is specifically designed for the control of greenhouse gas emissions. That became politically undoable. Perhaps in Q&A we can talk about why my assessment about why that failed might be a little bit different than some others on the panel. But there has been no legislation to deal with greenhouse gases, and so the primary mechanism that the administration has been forced to resort to is the use of the Clean Air Act, a law that has not been modified in any significant respect since 1990 and was written to deal with traditional pollutants that we are primarily concerned about in their ambient concentrations, primarily but not exclusively in and around metropolitan areas, a law that was not designed to deal with pollutants that are dispersed globally in the atmosphere and certainly not as ubiquitous as carbon dioxide and other greenhouse gases. Now, in terms of how we got here, it's worth giving a tiny bit of background of how we got to this point. Beginning in the late 1990s, some organizations and groups began to argue that the Clean Air Act, even if it had not been written with greenhouse gases in mind, and even if Congress had enacted separate provisions in the Clean Air Act to deal with other pollutants that create international concerns, such as chlorofluorocarbons and other substances that contribute to depletion of the stratospheric ozone layer. The language of the Clean Air Act seemed sufficiently broad and capacious enough to apply to greenhouse gases. And so in the late 1990s, some organizations asked the Clinton administration to declare that greenhouse gases were pollutants for purposes of the primary Clean Air Act provisions and to begin regulating them accordingly. The Clinton administration's response was to say initially that they thought they had this authority, and in response to requests from Congress, two general counsels of the EPA both told Congress that they believed EPA could make such a determination if it chose to, but then also said they had no intention of making such a determination, at least not yet. After the 2000 election, the Bush administration had even less interest in making a finding that greenhouse gases were pollutants under the Clean Air Act, arguing that insofar as greenhouse gases needed to be addressed, they should be addressed through some sort of global framework, because the ultimate concern with climate change is not the amount of emissions from any particular country, but the global accumulation of greenhouse gases in the atmosphere as a whole, and that were the United States to control emissions without ensuring that other countries would follow suit, there would be no guarantee that the overall concentrations would be lower. In fact, there would be at least a possibility that emission reductions in the United States could be offset by increases in other parts of the world, particularly in rapidly developing countries. When the Bush administration was finally threatened with suit for failing to act on the request to declare greenhouse gases as pollutants, the Bush administration reached its own conclusion that it had no such authority, and then further reiterated that even if it did have such authority, it would not exercise it because it felt there were better ways of dealing with greenhouse gases. In subsequent litigation, the Supreme Court ultimately concluded that the Bush administration was wrong on both counts, concluding that that pollutants did satisfy the Clean Air Act's definition of pollutants that would be subject to regulation, and rejecting the Bush administration's arguments for why it would be unwise to regulate greenhouse gases under the Act. According to the court, whether or not the Bush administration was correct as a policy matter, that it would be preferable to pursue greenhouse gas controls on a global basis, as a legal matter, the Clean Air Act did not give the Bush administration or any administration the discretion to make the decision to regulate or not regulate on that basis. Rather, under the terms of the Clean Air Act, if the EPA determines that emissions of a pollutant or could reasonably conclude that emissions of a pollutant cause or contribute to pollution that can reasonably be anticipated to threaten public health or the environment, then the EPA is obligated to regulate whether that is what the administration would like to do as a policy matter or not. So while the Supreme Court did not mandate that the EPA begin regulating greenhouse gases expressly, this ruling created a de facto requirement, a requirement that the Bush administration simply ran out the clock on and decided not to act on prior to leaving office. The Obama administration was not so reticent about using this authority, hoping in part that the prospect of regulating greenhouse gases under the Clean Air Act might prompt at least some opponents of such regulation to believe that a new regulatory framework under a new statute was preferable than using the Clean Air Act. But that was not to be. So the Obama administration made the threshold finding that emissions of greenhouse gases cause or contribute to pollution that has the likely effects of threatening public health, began regulating of emissions of greenhouse gases from motor vehicles, began regulating regulations from large stationary sources, some of which were subject to litigation, again in the Supreme Court, that were largely, although not completely, upheld in a case a few terms ago called Utility Air Regulatory Group, and then most recently resulting in something referred to as the Clean Power Plan, which is certainly the most ambitious and aggressive effort to regulate greenhouse gases domestically that we've seen. The Clean Power Plan is a set of regulations that are implemented under Section 111 of the Clean Air Act, and Section 111 authorizes the issuance of standards of performance for new and existing sources of regulated pollutants. It is a very ambitious undertaking. It is a undertaking that is already subject to legal challenge. In fact, it has the rare distinction of being one of the few regulatory initiatives that was actually subject to suit before the regulations were even finalized. Several states and industrial groups went to court seeking to enjoin the EPA from finalizing the regulations before the rulemaking process was even finished. And while they were ultimately unsuccessful in this effort, the D.C. Circuit took the argument seriously enough to have our oral argument on the question. So these regulations are ambitious. They face a somewhat cloudy legal future, and time permitting, I will suggest they may not actually represent all that meaningful a step toward the ultimate goal of atmospheric stabilization of greenhouse gases, no matter how ambitious they are as a regulatory matter. So what does the Clean Power Plan do? The Clean Power Plan's purpose is to reduce power plant emissions primarily from coal and gas and to some extent oil-fired power plants, by 32% below 2005 levels by the year 2030. And when we're talking about climate change and we talk about emission reductions, we always have to be careful to specify the baseline year that we're using to measure those reductions, because different agreements and different regulations use different years as the baseline. But for the Clean Power Plan, the baseline is 2005. And it's particularly important because power plants in the United States are responsible for approximately 1/3 of greenhouse gas emissions. So targeting the largest sources of greenhouse gas emissions for significant reductions is certainly an important thing to do if we're going to stabilize concentrations in the atmosphere. In terms of how the Clean Power Plan works, most of what you've heard about the Clean Power Plan, or may have heard about the Clean Power Plan prior to about a month ago, is not reliable. And the reason for that is because the regulations the EPA finalized last month are radically different from the regulations that the EPA had initially proposed and it submitted for public comment. A lot of the things that people thought the EPA was going to do, and it ended up doing quite differently. And a lot of the legal rationales the EPA initially offered for what it to do, it changed dramatically, almost certainly in anticipation of regulation. Basically, the Clean Power Plan primary rules focus on emissions from existing power plants, and then there is also a companion rule that focuses on new or modified power plants. That's important legally because under the Clean Air Act, a rule governing new power plants is a necessary legal predicate for a rule governing existing power plants. And that's a common feature of Clean Air Act regulation, treating older or existing sources differently from new or modified sources. Basically, the way these regs work is the EPA has identified what it believes is the best system of emission reduction that has been adequately demonstrated for specific source categories. So it's done this for coal, it's done this for gas, and then has identified the degree of emission reduction that is necessary under this best system of emission reduction. States are then expected and encouraged to come up with state implementation plans through which the states actually do the work of directly imposing these requirements on regulated facilities. States are given a lot of flexibility in developing these plans, but should a state refuse to develop an implementation plan, as some states have suggested they will do, the EPA is obligated to implement a federal implementation plan in its stead. The plan anticipates that these reduction requirements can be met either by improving the operation of existing plants through things like heat rate improvements at individual plants, or by things like substituting the reliance on coal plants with greater use of natural gas plants or greater use of renewable energy. The EPA had initially suggested that the standards could also be met by encouraging energy efficiency more broadly throughout the electricity sector and among electricity consumers, but the EPA abandoned that as a formal part of the plan, almost certainly out of concern for legal vulnerability of including that as part of it. As I mentioned, these regulations are going to be challenged in court, and there are a bunch of interesting questions that the courts will have to answer. One is whether the EPA has the authority to do this at all. And the reason that's a question is because Congress back in 1990 made two separate revisions to the relevant portions of the Clean Air Act in two different parts of the Clean Air Act amendments. And there is some dispute about which amendment is in fact the one that is properly incorporated into the Clean Air Act. And this is a concern because under most readings of these provisions, the two amendments are in conflict. That is, they cannot both, it is unlikely that they both could have been adopted. And so, at least under one interpretation, EPA does not have the authority to issue these rules because power plants are already regulated under other certain portions of the Clean Air Act. A second legal issue would be, did the EPA go too far in revising the regulations in anticipation of litigation and in response to comments? In administrative law, a final rule has to be a logical outgrowth of the agency's initial proposal. And the EPA was certainly very responsive to the comments it received, but I'm sure that some of the folks that are critical of the law will use this against the EPA, saying you were very responsive to us. In fact, you were too responsive, and you did some things we didn't have a chance to comment on, and so therefore it was not a logical outgrowth. There's also a question about what happens to the new source standards that I mentioned. The new source standards are a legal predicate for the existing source standards. They are premised on the idea that that carbon capture and sequestration technology, that is technology that takes carbon out of the emission stream of a coal-fired power plant and sequesters it away, has been adequately demonstrated. And the new source standards will be challenged on that basis. If they fall, the Clean Power Plan regs have to be set aside as well. And then there will be another interesting argument about whether the EPA's encouragement of what are called outside the fence line reductions, reductions that are achieved not by, say, improving the operation of a coal plant, but by getting the owner of the coal plant to use the coal plant less and use natural gas more, whether that is properly conceived of as the best system of emission reduction for an individual regulated source. And here again, there's this interesting conflict because one of the reasons EPA is relying upon outside the fence line measures is to make the rules more flexible and more easy to comply with, but that also creates a potential legal vulnerability. I see that I'm out of time, so let me just make one final comment. These regulations are ambitious. They're the most ambitious regulations we've seen domestically targeting greenhouse gas emissions, but they are also barely a drop in the bucket in terms of what we want to see in terms of stabilizing atmospheric concentrations, and in some respects could actually make some of the broader goals that our country has announced harder to achieve. So, for example, the administration has repeatedly said that its real goal is 80% reductions below 1990 levels by the year 2050, 30% reductions by the year 2030 from the largest source of greenhouse gas emissions in our economy is actually a very small step. And if achieving that step is done by making large capital investments in new facilities and in modifying facilities, investments that are expected to last for decades, a small step in emission reductions by 2030 can actually make it harder to make greater steps by 2050 because we will have made these massive capital investments. The other concern is that it's not clear these sorts of regulations encourage the sort of innovation which is ultimately necessary not only for the sort of emission reductions we need domestically, but for the emission reductions we need globally. Because the United States could stop emitting all greenhouse gases tomorrow, and we still would be on a path for continuing increases in atmospheric concentrations. The United States has a role to play in encouraging the innovation that is necessary to allow economic growth without increased use of carbon. It's not clear that these regulations contribute significantly to that goal, which is the ultimate goal that we should be seeking. Thank you.
Good afternoon. Is it afternoon? Hi. I'm Uma Autka. Very delighted to be here. Thanks to the Law School and the Center and Professor Kolaris for organizing this exceptional conference and panel. I'd like to take the opportunity today to address the Obama administration's Clean Air Act legacy and the United Nations Framework Convention on Climate Change, hopefully bridging the domestic focus of Professor Adler's talk with the international focus of Susan Binez from the State Department. So what I'd like to do is offer an overview of the EPA's Clean Air Act regulatory agenda as it relates to domestic obligations under the Framework Convention, as well as near-term positioning for the 21st Conference of the Parties in Paris, and offer some early perspectives on the administration's Clean Air Act legacy for climate change policy. So first, let's consider the U.S. within the International Climate Change Treaty context. Very briefly, the U.S. was among the first nations to sign the Framework Convention. This was the landmark international agreement by which now 195 parties have agreed in broad terms to the objective of achieving, quote, stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So as a signatory, the U.S. is committed, along with these other nations, to adopt national policies and take corresponding measures on the mitigation of climate change by limiting its anthropogenic emissions of greenhouse gases and protecting and enhancing its greenhouse gas sinks and reservoirs. The Kyoto Protocol to the Convention established binding emissions reductions for developed nations, and the U.S. had a significant role in designing that protocol, but ultimately, as we know, declined to ratify it because targets would not apply to polluting developing countries, namely China and India. And this was seen as a major setback to the success of the Kyoto Protocol, and the leadership position of the U.S. In climate change negotiations was seriously undercut. Nonetheless, though not subject to Kyoto, the U.S. has maintained its posture of commitment to the shared aims of the convention, including emissions reduction, through domestic efforts. And so the U.S. conveys its progress on climate measures via reporting requirements of the treaty. In 2009, after taking office, President Obama pledged that the U.S. would cut greenhouse gas emissions by 17% below 2005 levels by the year 2020, and he quickly encountered obstacles. The president's first foray into climate change negotiations, this is a picture from 2009 at the Conference of the Parties in Copenhagen, ended in frustration, protests, little progress. I'm sure Susan can tell us more if she cares to return to 2009. But I think we saw for the remainder of the first term, at least, a more low-profile role for the administration internationally. Many thought, as Professor Kalari said, that climate change legislation would pass in that beginning of the first term, and that failed in the Senate. So in the face of this kind of congressional gridlock and a warning, cautionary tone from the Clinton-Gore experience with the Kyoto Protocol, the president shifted his focus to see, well, what could be done with existing statutory authority. So reflecting this reorientation, that's where the Clean Air Act became the focal point of the administration's efforts to achieve climate change mitigation goals, particularly in the second term. So the origins of the CAA's centrality to this domestic climate mitigation policy traces before the Obama administration's before the election, with that landmark case of Massachusetts versus EPA. You know, that was a case that looked at the mobile source provisions of the Clean Air Act, focused on emissions from vehicles. It ended up providing a foundation for the administration's substantive Clean Air Act regulatory agenda pertaining to greenhouse gases more broadly. So it was Obama's new administrator for the EPA, Lisa Jackson, who issued the affirmative endangerment finding that new regulations of vehicle emissions and fuel economy standards were justified by that affirmative endangerment finding that greenhouse gas emissions cause or contribute to public health and welfare. So where do we get from the mobile source provisions to stationary source provisions? This is what underlied the Utility Air Regulatory Group decision that Professor Adler mentioned, essentially, this was a reading of the statute by EPA that the effective date of the so-called tailpipe rule, these mobile source provisions via the regulation, triggered the obligation of the agency to immediately begin to regulate greenhouse gas emissions from stationary sources. So this trigger theory would require power plant regulations, but much further. And so to many, many more stationary sources. So in 2014, in the Utility Area Regulatory Group case, you have the Supreme Court rejecting that triggering and tailoring concept, but several aspects of the opinion, I think, from a climate change standpoint are critical. One is the court did not revisit the endangerment finding or the tailpipe rule, so those were left in place, and it arrived at a reading of the statute that allowed EPA to require best available control technologies for greenhouse gases emitted at stationary sources if it was already permitting those sources. So they called it, in the opinion, anyway sources, and this ended up being most of the sources that would have been regulated under the tailoring rule. So just quickly, why this focus on the energy sector? Professor Adler made remarks on the significance of this in the scope of greenhouse gas emissions overall, but you can see the role that electricity and transportation combined contribute to the greenhouse gas emissions, greenhouse gas pollution of the United States. Electricity being the power plants, transportation being vehicles, both of these are covered by Clean Air Act. So you can see the centrality of the statute as a source of executive action existing statutory authority. So critical subsequent regulatory developments under the Clean Air Act, the Clean Power Plan that he mentioned, categorical standards for new power plants, guidelines for existing power plants, and lastly, for our purposes, EPA's proposed regulation of methane, a potent greenhouse gas from new sources within the oil and gas industry. So this rulemaking is an important part of a much broader climate action plan that the President announced in 2013, which outlined 3 primary goals: continuing to accelerate the reduction of carbon emissions in the United States, helping state and local governments prepare for climate impacts, and leading international efforts in globally reducing greenhouse gas emissions. So the first and third goals have proven to be intricately connected, I think, by the Clean Air Act regulatory agenda. And assessing that connection is an opportunity to consider how that work intersects with the Framework Convention, with aspirations for a new and robust international agreement, and with other factors that I think will complicate the formulation of the administration's climate change legacy going forward. So we can first look to the intended nationally determined contribution, or INDCs, that countries have been submitting under the convention in anticipation of the Paris conference in December. So in March of this year, the Obama administration submitted its INDC, stating an intention to achieve an economy-wide target of reducing greenhouse gas emissions by 26 to 28% below its 2005 levels in 2050. The Clean Air Act rules that we've just summarized in brief comprise 4 out of the 5 measures that are identified in the INDC and qualifies national policies on mitigation of climate change that were required in that core treaty text. So though it's too soon to project the contours of the President's climate legacy, I'd like to offer a few early perspectives related specifically to the Clean Air Act. First, it's a clear achievement of the administration, I think, that the regulation of greenhouse gases is now solidified under the Clean Air Act. Whether the Clean Power Plant sustains legal challenge won't change, I don't think, that fundamental point. It would almost surely relate to instrument design, not the premise that the Clean Air Act is available as a legal tool. And this is important in several respects. From the 2011 Supreme Court opinion, American Electric Power versus Connecticut, we know that Massachusetts versus EPA and its recognition of EPA authority preempted federal common law litigation on greenhouse gas emissions even before the agency had taken action pursuant to the authority recognized in Mass v. EPA. So doing so, the Obama administration's acts to do so filled that gap. It's also important for undercutting the perception that congressional gridlock was a completely impervious barrier to climate progress, which was a sense that I think many people felt with a thud after the failure of the 2009 bill. And a result that I connect with this turn, at least in the energy space, is toward a turn towards a generalized view that a low carbon future is ultimately going to be inevitable. And I see this shift as one that might be a powerful force potentially behind the technological innovation that Professor Adler and others have argued should be the central policy principle. Second, this Clean Air Act legacy carries significance for the Framework Convention context and for the U.S. posture approaching Paris. It's reflected in the Clean Power Plan introduction, the final draft of the rule, which explains, and I'll quote, "The rule establishes the foundation for longer-term greenhouse gas emission reduction strategies necessary to address climate change, and in so doing confirms the international leadership of the U.S. in the global effort to address climate change." So the Clean Air Act rulemaking has helped provide a basis for advancing, once again, a leadership role, and, for example, pursuing bilateral climate agreements with other nations. China, for instance, you can see, that looks a little strange, but you can see the controversies that prevented the U.S. from participating in Kyoto were not small. This just compares the United States and China as, United States is the second largest emitter, but that when you look at annual emissions in contrast to historical emissions, in contrast to emissions per capita, there's different pictures. So there's reasons for there to be disagreement about how to proceed. But to achieve an agreement with China, whatever objections there may be to the substance of that agreement, is widely viewed as an important shift in that dynamic that prevented U.S. participation. But the statement in the Clean Power Plan goes further to reflect that there will be more necessary to achieve decarbonization. There's two poles of the critique for Clean Power Plan, aside from the faceted legal arguments that we'll see. One is the rule's too aggressive. One is it doesn't go far enough. There are also questions about whether the rules, Clean Power Plan and the other rules I've mentioned taken together set up the U.S. even to achieve the INDC. And the administration is still projecting confidence in those numbers, but other estimates show the possibility of falling short. So this is one estimate from Center for Climate and Energy Solutions showing where even to reach that goal, more would be necessary than the Clean Power Plan and related measures alone. So one of the most promising options for additional reduction might be methane standards for existing oil and gas wells. But to date, there's no certain indication that the administration will pursue that. And so this is where I think mixed messages from the administration have been hard for observers to reconcile with the commitments that underline the Clean Air Act rules. Two key examples that are fairly familiar to everyone, and one is the Keystone Pipeline, a highly contentious and thankless issue for the administration, to be sure. This is an example where some climate activists have regarded it as a sort of litmus test on the president's commitment to climate mitigation. Earlier this year, he vetoed a bill that would have approved the pipeline, but the project is still officially under State Department review. He said a decisive factor in the review would be the effect on climate change, but has not formally approved or rejected it. Another is drilling in the Arctic. So the administration's recent approval of exploratory drilling permits for Shell is confusing for on the environmental side. So at a time when the president's keen to reduce greenhouse gas emissions, why encourage new sources of fossil fuels that would, at least from a climate change standpoint, be better left where they are? So at the same time, there are clear areas of achievement apart from the Clean Air Act rulemaking that demonstrate the president's commitments. Support for renewable energy and energy efficiency are prime examples. So we'll see in time how his decisions across a varied range of areas come together to be judged as a climate legacy. So in sum, All domestic climate action by the president using existing law does at minimum two things relative to the international context. It fulfills the long-standing obligation for national policies under the Framework Convention, directed at reducing climate change, reducing greenhouse gas emissions, and it does make U.S. efforts to lead on the international stage more credible. According to some legal scholars, it may do more still, providing a basis for the president to make parallel legally binding international commitments. And I'll close there and turn it over to Susan, since this is her expertise, and look forward to your thoughts and in discussion.
I want to thank our panelists very much for their wonderful presentations. I have three questions, one for each panelist. For John, you say the finalized regs in the Clean Power Plant will likely be challenged because, quote, they were not an outgrowth of the current rulemaking process, end quote. EPA has stated that the changes in the final rule resulted from a concern for creating enough flexibility for the states. If indeed the administrative record supports this rationale, and if, as expected, the Clean Power Plant rule does provide that flexibility, and the state plaintiffs expected that rule, how can they claim they are aggrieved on this particular basis, i.e. that they are not an outgrowth of the current rulemaking process if they're actually the beneficiaries of it?
Detailed into Adler everyone wants me to get, but the general requirement of administrative process is that all potentially affected parties have notice of what an agency is thinking of doing and an opportunity to comment on it, not just in the large outlines of it, but even in some degree of detail. And this is a reason why agencies, when they propose rules, will often set forth a menu of options or a range of options that they're considering. So in the emission reductions context, EPA will often propose a rule saying, we're thinking of doing something within this range. Here's what we think is here's where we're leaning right now, but anywhere in this range might be the degree of emission reductions, or any one of the following mechanisms might be the best way to achieve that reduction. And then, as a result of comments, they choose from among that menu. Insofar as they go outside the bounds of that, the argument is that they're selecting something that folks did not have enough opportunity to comment on. And so even if states or the coal industry or other folks think, well, the general nature of the changes were good ones, there are still things that perhaps the agency did not think about because we didn't get a chance to comment on those as well. As a general matter, I think as a legal matter, it's a strong argument to make. The other interesting twist is, in the DC Circuit, there is a practice of remanding regulations that did not follow proper procedures without vacating them. So basically saying, yes, the agency screwed up, they should have done something differently, but there's very little reason to believe they would have done something that much different than what they did. So we're going to make them go back and produce more paperwork and produce a greater explanation, but we're not going to disrupt the schedule upon which the rule is operating. And EPA, I think perhaps even aware of that possibility, gave the states more lead time in terms of their ultimate compliance date. And they did that, I think, both because they didn't want courts to issue a stay of the rule. They wanted the train to keep moving. And I think also, if courts find that, yes, procedurally the EPA should have done something different, it makes it easier for the EPA to argue, okay, we'll fix it, but let's keep the train going. We have a schedule that says the first emission reductions are supposed to really be, or the first targets begin in 2022 and build up to 2030. That's far enough in advance that if, yes, we'll add some explanation, we'll take some additional comments, we'll consider doing some tweaks along the way, but let us keep going. And I think that's, if I had to predict what would happen with those arguments, I think that's a reasonably likely outcome, that courts accept that the regulated community has some reasonable complaints, but not large enough to actually vacate the rule on that basis alone.
Thank you. To Professor Autka, critics and supporters, and here Nicholas Stern of the Stern Report fame comes to mind. So critics and supporters of the Clean Power Plant have pointed out that their regulatory stringency does not match the announced U.S. commitments prior to COP21, the deal in Paris, the agreement, the meeting in Paris in December. Without throwing the baby with the bathwater, what can be done? Is this an example of the administration waiting for the outcome of the negotiations to make any subsequent adjustments more politically palatable? If not, what is your intuition about this?
Okay. Well, it seems that there are other options that could be pursued if the administration wasn't boxed into trying to work with existing authority, that it doesn't need to seek new congressional action to achieve. As of now, the president's basically saying he still has faith in those numbers. A lot of other sources are saying it will fall short, not only looking at the Clean Power Plan, but looking at the suite of Clean Air Act regulations that affect greenhouse gases that we've looked at. Some of these are categorical, they're forward-looking. Some are specific facility permitting limits that would be set case by case. I think Susan said it well when she said this is something where it's a balance of trying to do what is achievable in that rule. I do want to make one remark, though, which is, I think, something very interesting that we've seen in connection with the promulgation of this rule, which is even among the states that are announcing that they'll be first in line to challenge it, many of them have been planning how to comply with it. And I don't think that that's only defensive. I think that there is a shift in how people are thinking about the options when faced with the possibility even that they will be made to pursue them. And that is an interesting shift. So I think to the extent that that continues, there may be more potential to achieve higher levels of reduction even using Clean Air Act mechanisms.
Questions from the audience, please identify yourself and direct your question to the panelists you desire. Thank you. Stand up, if possible.
Well, I have just a really quick question for Professor Adler. You said you had a different narrative for why the United States legislation did not pass. Could you briefly provide that narrative?
Sure. It was the Waxman-Markey bill was, primarily billed and sold as a cap and trade bill, but it was far more than that. It included all sorts of subsidies and mandates. It even included dramatic expansions of federal regulatory authority into areas of law that are traditionally considered to be state and local government prerogatives, so much so that even the Washington Post thought this was a real problem and saw the need to editorialize about it. And it combined both a dramatic expansion of regulatory authority with a dramatic expansion of what is best characterized as crony capitalism. I mean, the idea behind the bill was we'll put limits on what big companies can emit, and then we'll hand out credits to them. And certainly for what was then the emerging Tea Party movement and the like, that's the worst of both worlds. That's more government power and more goodies to Washington insiders. And then when you kind of started to open up the bill and look at, for example, the way agriculture was going to be treated and the way it was going to, all compliance was going to be done through USDA as opposed to a regulatory agency that might actually want to regulate the agricultural sector in a meaningful way, it became clear it wouldn't even achieve its own goals. So it was a regulatory monstrosity combined with crony capitalism that wouldn't even achieve the environmental goals that it set out for. And so there really wasn't much on offer. And so it barely passed in a Democratic House that had a wide Democratic majority and was dead on arrival in the Senate. And unfortunately, since then, there has been very little effort to think about what sort of approaches to reducing greenhouse gas emissions might be more compatible with the various concerns that various interest groups and kind of ideological cohorts have. And until that happens, my own view is we're not going to see much progress, and that's unfortunate because we need to see progress.
Next question, gentlemen.
Hi, I'm Chuck Hall. It seems like the solution to these problems is really economic and technological, that the real impacts that we're trying to negotiate through is how we deal with the increased cost of reduced emissions facilities. What do you see as the incentives that are being provided to develop the technological aspects or to decentralize power production that can reduce the impact of the economic impact of the reduced emission power production facilities?
Is this question directed to the entire panel? Sure. Thank you.
I think you're exactly right. And if you look historically, you look at things like CFC phase out, which was a much easier, less complicated, less costly thing. When did the United States sign on and push the Montreal Protocol through? When it was cost effective and we knew how to solve the problem. It will be the same as carbon. We will get the degree of reductions we really need to see when it's cheap and easy to do. And we're not doing much to make it cheaper and easier. We're spending more time focusing on midterm targets that in some cases will actually make it more expensive to meet longer term targets. And well, I mean, there's, you know, and you can see in countries like, you know, Germany, for example, was dramatically reducing coal use from like the late 80s until 2011, and then it decided it was going to phase out nuclear. And what happened? Coal use started going back up. And what's the dominant source of coal in Germany? Lignite, which is the worst for this. I mean, it's very hard to do. And but we know when it comes to technology generally, if you can have a sort of dramatic breakthrough that dramatically reduces the adoption of a transformative technology, like fiber optics replacing copper or wireless replacing fiber optics, it can happen very rapidly. And then having an agreement that meaningfully encourages and pushes rapid progress is more doable. So my own view would be, and this may be unpopular, is we spend too much time thinking about midterm targets and almost no time thinking about innovation. And that's backwards, and it means we're more likely to fail in the ultimate goal.
Okay.
Seems like that's the better use of government funding, like carbon has been a very successful program, although it's focused in a different direction.
Yes, the question is, you can't avoid the political. The question is political, but it obviously involves technical, scientific, and economic determinations. We need to at least one more question from the audience, and if, I would suggest that the audience direct questions to our two guests, Advisor Susan Beniez and Professor Altka, please.
It was talked about it's my understanding that the overall monies we devoted to alternative energies, wind, solar, whatever, have only contributed to like 3 to 5% of our energy needs. And lip service has been given to nuclear, but I don't hear anything about new nuclear plants being built anywhere in the United States. And it's my understanding that fusion, if at all, is 30 to 50 years out. So
It's always 30 to 50 years out.
So aren't we kind of spitting in the wind on this issue?
You want to try that, Professor Altka? It's your area.
Yeah, I guess this ties into your question a little bit too about economics. I think my sense, without focusing a lot on nuclear power and in my research, my sense of in reading in this area is simply the immediate economics don't seem to work. And so there's theoretical questions about whether the low carbon profile of nuclear makes it desirable, notwithstanding the long-term radioactive waste problems that we have not solved. But those questions don't even really get engaged fully given the short-term economic barriers that there are. But I do just want to make one final point regarding how we think, how we talk about, at least, the economic effects of taking climate action, and that is it's very easy to get localized into thinking this is expensive, therefore we shouldn't do it. But the long-term costs, the long-term economic impact of not doing anything, of delaying action or doing nothing, you can find so many sources from the world of economics showing that that's so much more expensive in the long term. It's just a lot harder to think long term, and it's harder to figure out how to reconcile that with immediate pain.
Well, that will be all for our panel, and please join me in thanking them for coming here and doing a terrific job.